Stuart here from Public Law Hacks, where we bring you simple guides to public law. Before we start off today, please like the video and subscribe to the channel for more content. So today we are going to be looking at the Human Rights Act of 1998. Now, the European Convention on Human Rights is an international law that the UK has signed up to, and it sets out a number of human rights protections such as the right to life, prohibition on torture, and the right to liberty and security. Now, the Convention is interpreted and applied by a court called the European Court of Human Rights, and people take human rights cases to the European Court of Human Rights, and it passes judgments on alleged violations. Now, many people mistakenly believe that the European Court of Human Rights is part of the European Union, but it's not, so make sure you don't make that mistake in your exams. Now, the Human Rights Act was passed in 1998, and it makes it possible to raise complaints about violations of the rights in the European Convention on Human Rights against the UK government in UK courts. Now, I'm going to run through some important sections of the Human Rights Act, but before I do that, it's worth noting that most universities allow students to bring copies of statutes into the exams, which include the Human Rights Act, so that can be helpful in case you forget the numbers or sections. Now, the first section we're going to look at is Section 3, and under Section 3, this requires courts in the UK to interpret UK legislation as far as possible so that it's consistent with the European Convention on Human Rights. When the UK courts do this, Section 2 of the Act requires the courts in the UK to take into account any judgment made by the European Court of Human Rights. Now, two things are important to note here. The first is that UK courts are not bound by the European Court of Human Rights' judgments in the same way as a lower court is bound by the rulings of a higher court in the UK. They will usually take the European Court's judgments into account and follow them, but sometimes the courts in the UK can decline to follow a decision from the European Court of Human Rights. And an example of this is the case of Orr versus Horncastle, and you can see this quote from Orr versus Horncastle on the screen right now. Now, sometimes it is not possible for the court to interpret the law consistently with the European Convention on Human Rights or the jurisprudence of the European Court. Now, this will lead to one of two outcomes. Now, if the law in question is classified as subordinate legislation, which is set out under Section 21 of the Human Rights Act, and includes things like statutory instruments and acts of the devolved institutions, such as acts passed by the Scottish Parliament, the parts that are incompatible with the Convention can be declared invalid by the court. Now, if the law in question is classified as primary legislation, which includes public acts of the Parliament in Westminster, the court can issue a declaration of incompatibility. This tells the Parliament that the law is incompatible with human rights, but does not make the law itself invalid. It's then up to the Parliament to decide whether to change the law, but they are not obliged to do so. Two other sections of the Act are worth looking at. Firstly, under Section 6, it is unlawful for a public authority to act in a way which is incompatible with a convention right. The public authorities here include government departments like the Home Office, the Ministry of Defence, etc. And it also covers things like the police and hospitals. It means that when they do things and make decisions, they have to act in a way that complies with human rights law. So when the police arrest people or police protest, they have to comply with human rights law. Now, if the public authority doesn't act in a way that complies with human rights law, Section 8 allows the courts to provide remedies for victims. These remedies can include damages or stopping the public authority from violating the person's rights. So if a person was detained in violation of their right to liberty and security, for example, the court could order their release. We'll be looking at how the Human Rights Act works in judicial review in another video, so stay tuned. So that's it. Please like the video and subscribe, it really helps us. And if you'd like to ask a question or request a video on another topic, please leave a comment below.